get it started. Thank you all for coming to the Notarial Act work group. I'm Mark Comstock, a commission member, and I guess I'm running the show here. Let's go around the room first, and then we'll figure out who's out in the ether. So to my left. Sandy.
Sorry, Sandy Weintraub. I'm the director of the Oregon Law Commission. My role is to convene and coordinate the group. So you'll see emails from me, and anything I can do to help, please let me know.
Sam Dupree with the Oregon Judicial Department. I'm a staff attorney that deals with mostly e-services.
Peter Threlkel, Director, Corporation Division, Secretary of State's Office.
Amy Dexter, Oregon State Bar.
Kevin Christensen, Oregon Bankers Association. Matt Markey, Oregon Bankers, or Oregon Bankers.
Who are you today, Matt?
Marisa James from Legislative Council. Liz Basemar, Quick and Long.
And out on the ether, who do we have?
This is Ken, Chairman.
Thank you, Ken.
Renee Alberti with Notary. Melissa May with Duffy Keckles.
Okay.
Michael O'Neill with First American.
Katie Clark with the Northwest Credit Union Association.
And this is Tommy Brooks with Cable Houston.
That should be good.
That's it? Okay, great. Thanks all for joining us. I hope everybody got the written material that was sent out by Sandy sometime last week. We had a brief meeting summary from our meeting in January. Anybody have any additions to that we may have not identified, or corrections or anything like that?
I do have more detailed notes, but this is what I included in the summary specifically. It's also available, which I'll post on the website. We're doing a little work on our website at UO, but the whole meeting's recording will also be posted on the website before too long. And Sandy, why don't you tell us where we are on the related legislation, the 2425? The only bill that 2425, and Katie from the credit unions, are you there?
Yes.
Do you have, you may be able to help me more on this than I know. Did you work on this bill specifically?
No, Pam Levitt with the association does.
So this bill is, from what I know about it, I'm not an expert on it, but this specific bill allows for a county clerk to record electronically or a record bearing electronic signature. It doesn't, Pam, when she was at the last meeting, talked about how this could interface with our work. No one believes that this is going to interfere with our work, but it could be related to it. And basically, I think the idea behind it is that how it connects our work is it's the legislature becoming more comfortable with passing legislation about utilizing electronic signatures in more avenues. I don't really know a better way to describe it other than that. I don't think we need to talk about the technicalities of the bill here, but just to know that bill has now gone through Senate committee after House committee. Oh, that's true. Pam.
Hi.
Hi, nice to see you. I first not there. We're actually just talking about 2425.
Oh, yes.
And so you're perfect timing. If you want to elaborate any specific details about how it might interface with our work.
Well, I think there was some confusion, not only with some of the counties, but also lenders on what document or about electronic signatures on trustee documents. And we wanted to make sure, put it in statute and make sure it was very clear. We met with the title companies and the mortgage bankers and the bankers, and we had two representatives from county clerk's offices there, and they participated to get the bill drafted, and it seemed to be, everyone seems to be really positive about the bill. 2 days before the hearing on the Senate side, after it passed unanimously on the House side, Multnomah County came in and wanted to use our bill for its relating clause to clarify that the current statute on fees on the documents they give to consumers would stay with electronic documents. So I, of course, wanted to make sure that that was not something that legislators were going to oppose because it was on my bill, and I don't think there was a lot of lobbying done on that issue. So the chair was fine. I checked with all these guys, and everyone seemed to be fine with the amendment. And the two legislators who raised concerns didn't have enough concerns to have any problem in committee, but there were a couple that had vocal concerns to me. So that's it. It should be on the way to the Senate floor. I haven't checked today. It should be close to third reading.
Great. We have Liz, and
what was your last name?
From Quicken Loans, who's had experience in lobbying this bill, or similar bill, the Lona, through what, Arizona and Washington?
Washington, Idaho, North Dakota.
Okay, great.
Iowa as well.
Can you kind of give us a little bit of your experience in what the concerns have been in these other states?
Yep, and I know Renee and Michael O'Neill online as well. They've got experience across the country too. My experience with the hesitation is usually just the stickler things like the living trust issue. And what fees may be involved in just educating the legislators on what this would mean for their constituents. It's still a choice, not something that we're taking away. It's another option that we're adding. And then making sure you address the recorders' issues if they don't know how to e-record, or if they can't e-record, do you have an option for that, or is it time that everybody kind of upgrades? And then making sure that you keep everything technology neutral, so that when you have people coming on board for an open business platform, they can get more competitive and offer more, more options for the client.
Okay. Have you, anyone or any legislator or Secretary of State's office raised any concern about maintenance of the record, if you will, of notarization?
The record as far as like journaling requirements, or?
Well, not necessarily journaling, but my recollection is, and maybe I'm wrong here, that there is potentially a requirement that there be some kind of audio-video record of the signing. And has anyone raised questions about how that is saved, stored, or let's just say if a notary says, I'm done with this, where those records end up going?
From what I've seen in the States, a lot of it's treated similar to the journal, where if the notary passes or their license is revoked or their commission is revoked, that the Secretary of State can own their journals and the recordings as well. We believe that the actual bill should write in that there can be a custodian for the recording. So the title company can store the video for the notary as well, so that way it's not always in their hands. And then your current data breach laws and other fraud protections that you have in the state will help make sure that the systems are up to par for any of those issues. But it hasn't been a huge build-up, or it's more just a discussion topic to make sure it's addressed.
Okay. Any discussion about the cost of that, or is that raised at all?
I haven't heard a lot of issues with it, because a lot of the platforms are built to make sure that they can have the journaling requirements. And I know, Renee, do you want to take over on what you guys do at Notarize and maybe Michael O'Neill, because there's a title company in the platform?
So from a cost perspective, there really hasn't been a lot of conversation about the overall cost, because the storage of these videos and the records themselves are typically being done by a vendor like ourselves, or as I think Liz said, title agents are also storing copies of the information, as well as with cloud storage. It is extremely inexpensive. So the vendor itself is what we are storing the information on behalf of the notary. as well as the participant who, so like the actual borrower who uses, or the signer who comes back to look at copies of their documents, their audit log, as well as the video. They can do that all through our platform. So they'll always have their own access to that information as well.
Okay. Peter?
So can the Secretary of State get access to that, or is it only by permission of the notary?
No, actually, we do have the notaries agree. They're all employees of ours. They agree that we can provide access to Secretary of State, any regulatory agency, of course, with the appropriate request. We would provide that information. It's not actually having to go to the notary. Again, every vendor can handle it differently, but that's how we handle it.
So is that a license that is granted to the regulatory body?
No, it's not a license. All you would have to, as the regulatory agency, all they would need to do is actually just make a request to us, and we would provide you a copy of the information you're seeking on behalf of that notary.
Liz, could you give me kind of a count where the Rulona is adopted so far?
Yes, let me pull it up really quick. I know out of my states which ones were Rulona, because there's the Ultra model as well. But I know that for my, sorry. I have Washington, Idaho, North Dakota, Iowa, Minnesota. Those are out of my states. Michael O'Neill or Renee will have the rest of them, because they only have like 14 states.
Okay.
I'm tracking that I know for sure are Rulona.
Michael or Renee?
The only other Rulona state that so far has passed is Montana. They took the Uniform Act and put a lot of what I would call regulatory detail in it as well, but it's essentially the Uniform Act. Minnesota, does not really use the Uniform Act. They enacted their law before the ULC was finished with their final product last year. And so it's slightly non-conforming in form, but in substance it is conforming. So I think those are the 5 states. I think there are, and Maryland as well. I should throw in there. Maryland just passed, has not been signed by the governor yet. There are, of course, 13 states that have Rulona, and those that have Rulona have introduced bills based on the Uniform Act, and that would include Pennsylvania and Colorado, and those bills have not gone through this year yet, or will not go through, but are expected to be introduced next year. So I would say states that have Rulona, because Rulona deals with so much of these questions we're talking about already in such a comprehensive way, that using the Uniform Act addition makes it just a lot easier from a technical legislative standpoint than non-Rulona states. I will caveat by also saying that 2 states that don't have Rulona, Alaska and Hawaii, are actually looking to introduce Rulona, and New Mexico possibly as well, introduce Rulona, the whole thing, in connection with remote notarization, the remote notarization piece. So I actually am really optimistic that Rulona will go beyond the current 13 states and include additional ones next year. I want to comment on the question that was raised about cost, and this is something that has become a conversation piece in some states. So the cost in relation to the fees that are charged for remote notarization are very de minimis. At the cost of cloud storage, we've run some calculations, and it's a fraction of 1% of possible fees that could be charged. But one thing that should be looked into is Oregon's current fee structure for notarizations, and I believe that there is a $10 cap for notarial acts today. And states that have a fee cap that low have run into issues of actual adoption of this technology. So I'll give you an example. Indiana initially set a cap at $15, and they're already looking to up that to $25, simply because the $15 threshold has turned out, the current marketplace not to support, the broad range of technology solutions out there. So one thing that this group may want to look at is the current fee provision in Oregon law. Again, that's not a uniform provision of Rulona. It's something that was added in when you enacted Rulona, but it may be inadequate actually to sustain remote notarization at $10.
Here.
So the fee in Oregon that a notary can charge is set by rule by the Secretary of State. And part of what we've noticed is that there's an awful lot of states that only allow a notary to charge $1.25, ridiculously, what we would determine to be kind of prohibitive for the act, very low. Oregon at $10 is probably on the higher end for a regular notarization, but what we've noticed is electronic notarizations do tend to come in at about $25, and as a separate transaction. So.
Now, Liz, you mentioned the Alta model, and we've not seen the Alta model. Can you give kind of a high point?
Yeah, I mean, it's designed to work well with the ULC model so that all 50 states can be, conducive with each other's laws. It's not, the Rulona one is more structured to the point, hits all the main points and leaves the rest of it for rulemaking. Also, the model does that as well. They offer a little bit more with the paper out option, I believe, is from the Alta model, and different avenues that you can plug into the ULC bill. But with the states that I've seen that are already Rulona, they have a much faster process adopting this tiny amendment to add to their law rather than going through the other route.
Is there any benefit to the Alta model?
I find either one. I think the ULC one is the preferred method just because it's a lot broader and allows for the SOS office to do what they need to do in the regulation phase.
I can tell you from an institutional standpoint, both the American Land Title Association and the Mortgage Bankers Association equally endorse the uniform law. We, as an organization, worked really hard to make them consistent in terms of broad policy outcomes so that we can say that either model will work. And as Liz said, with states that already have Rulona, adopting the Rulona amendment is just much simpler, and is fully supported by the mortgage and title communities.
Any questions other than my questions? Guess I'm the only unclear person.
I actually, this is a layman's question, but do other states have different fee structures for remote notarization versus? I'm just wondering if there's.
The way some states are handling the fees, there are a large number of states set it at $25, and then that gives you theoretically a high enough threshold that different technology providers can compete at cost below that in the marketplace. Another solution is one that hasn't passed yet, but South Carolina is toying with this idea, and that's more along the lines of saying, let's have technology fees kind of like what notaries can charge for travel, which is you can charge an additional discretionary fee for technology just like for travel, but you have to disclose that fee up front. And so you separate the notarial act fee from a technology charge that's sort of a pass-through. So those would be the two models, but by far the vast majority of states are just setting it at $25, and that's what we've seen today so far.
And Michael, correct me if I'm wrong, but with the remote notary, there's not an additional necessarily cost to the client. With someone who wants to close remotely in their home, they're charged that travel fee,
right,
which could be, depending on where they live, it could be very expensive and how hard it is to get to them or how difficult it is to get a notary out there. So this should actually save some clients money in the long run, depending on how they want to close.
That's right. That's right.
So is our travel fee set in rule as well, or is that just full discretionary? Or?
It's discretionary. So for the notary and the client to negotiate, it just has to be disclosed up front.
Yep.
So is there any review about complaints about an excessive fee from the Secretary of State's office?
We have a complaint process. I can't recall that there's ever been anything that anybody's ever complained about the travel fee. You know, I think that, you know, probably the only thing that we would get into there is if a travel fee was quoted and then a different fee was charged when the notary showed up. You know, so
Oh,
that's,
I'm happy to pay for it.
yeah.
Right.
Yeah, and if they don't like it, they still have the option to drive into the office to close.
Right, yeah.
So
Yeah,
I'll still be
a lot of times, you know, I mean, it's at the borrower's convenience. You know,
Yeah.
they come to my house, it's an after hours, I don't have to take time off work, I don't have to drive downtown. Yeah.
Okay. Other questions at all? Okay. Well, the charge to this work group is to kind of consider whether we want to go down the road of remote notarization, and if so, what kind of legislation you might want to do. So I guess that I'm going to pose the big question: do we want to go down this road at all? And since y'all have shown up, well, that's kind of the question. So I'll pose that to you now.
Yes, yes,
Yeah.
yes,
Yeah,
yes.
for me,
yes.
I think yes, yeah.
Ken?
Yeah, I think there's a lot of benefit that can be derived from this. I mean, I think of people out in remote parts of the state and how this could make their life a lot simpler. I confess I have not made a very thorough study of the legislation, the uniform draft, and I'm just thinking about process. I assume that if the answer to your question is yes, we think this has merit, that we would then maybe have legislative counsel when they have the opportunity, and I know that they're pretty well engaged right now, actually put together an Oregon draft of this, and then that we would sit down and do kind of a section by section review of that draft. Is that what y'all have in mind?
Well, that's what I had in mind. The second question kind of is one where do we look at the Rolona? Do we look at the Alta? Do we look at a blank page and kind of decide what we want to do? That's kind of where I was looking, but I'm just trying to figure out if we want to go down this path. And I've got some subsidiary questions there that might be of interest.
Mark, I have in my file a document that was prepared last October. It's called Remote Notarization Comparison Between the 2018 Uniform Law on Notarial Acts and Model Legislation for Remote Online Notarization of the Mortgage Bankers Association and the American Land Title Association. I'd be happy to forward this to you. I think it was put together by advocates for the Uniform Act, but I remember reading through it several months ago and thinking, well, it does do a pretty good job of setting out the differences between the two. And I also have copies, if you don't have those available, I have a copy of the UTLA MBA draft bill, which I would be happy to furnish as well.
Well, Ken, I think Sandy has copies of those, and
Okay.
yeah, I appreciate your offer.
Do you have the comparison?
I do, yeah. Ken, I believe you were in communication with Lane Shetterly about this before we convened this group, and Lane did forward those documents to me. We
Okay,
decided
good.
to have the discussion about which way we're going to go first, but I do have those available if the group would like to see them.
That sounds good.
Anybody have want to make the case against going down this road? I don't see any. I see heads shaking in the room. So, anybody on the phone want to make that case? Well, I think it's then consensus that we want to go down that road. Let me ask this. Are there areas that we want to exclude from remote notarization?
Certain situations,
Well, I'm thinking of certain types of documents
certain documents.
that would,
We're all thinking about.
well, outside of the mortgage, bankers' concerns, I understand that part, but I'm thinking I don't think we have anybody that is an estate planner, but maybe Tommy, are you? Melissa?
Oh, I'm here, yeah. Yeah, I don't object to the concept of estate planning documents being remotely notarized. I do think we might want to look at placing a little more regulation in place around, I think right now the only thing in our notary statutes about competency of the client is basically the statute that says a notary can refuse to notarize something if they don't believe that the person has capacity or is doing it willingly. And I think we might need to provide more guidance for remote notaries as to how to make that kind of determination, because I think that's going to be a lot harder to do on camera than in person.
Okay.
Yeah, I second that. Our view is that, a lot of times when a notary is engaged, somebody walks into maybe an office, there's no prior relationship, no prior knowledge of the person. They're making, a quick assessment. Under Oregon law, that notary might be an 18-year-old individual who's a clerk at a UPS store. And so, they don't have the background, they're not mandatory reporters. They don't have that experience necessarily to gauge somebody's mental capacity other than a quick couple of questions. The person seems like they're have their wits about them, that they know what they're doing, and the notarization proceeds. So typically at Secretary of State, where we run into issues down the line, somebody's transferred title to their property, their farm, their house, and now the other heirs that were cut out of a will or of a transaction are coming in and looking to dispute, and they go back to it's the notary was at fault and the notary allowed this to happen versus the sister or the cousin or whoever that was behind getting grandma to sign off on everything.
Well, it sounds like we have a consensus that we're going down this road. Does anyone have, any other concerns that we might want to think about before we kind of identify whether we want to do the comparison of Rulona, Alta, and blank page?
One of the things that we've heard is that I don't want to go to the weeds as far as protections for folks is a very big issue, which two frameworks may do a better job of that. Being one. Number two, and one we go back and forth with is the ability to work across state lines consistently. I think that's a real big issue of different states doing a whole bunch of different. While the concept may be the same throughout, each state's got its own little nuance. On one hand, we can't avoid that entirely, but trying to find something that is, what's happening in Virginia, does it work in Oregon, and vice versa, what are the implications? I think that's where the real sweat's going to come from. So I think we're going to pull up this is trying to reconcile as much of that as we can. And I guess along the lines of national as well.
Okay. Liz, could you, or anyone, could you tell me what California is doing, if anything?
To my knowledge, California's not going to go through this year. There's been a couple holdups with, I believe it's the holdup and having the trust issue. They also have a lot of their efforts in CCPA right now, to be honest. So it's been more of the focus from our end as well, is making sure that that issue is taken care of. So we've not been as involved as we could be to make sure that that goes through in California. But
which version is California considering?
I believe there's an Alta MBA model.
Okay.
And to add some commentary with that, I feel like the ULC version is made for the Rolona states, and then the Alta model is more a substitute if you're not already a Rolona state, because that would be an overhaul of all your notary laws, which we're hoping, like South Dakota, who hasn't updated their laws in quite a while, we're actually trying to get the ULC to get more active there and turn it into a Rolona state, because I do think that that's a lot cleaner, especially with the cross state lines having the same basis model in as more states as you can.
Yeah, this is Michael O'Neill again, just to underscore what Liz said. That's probably the key difference and the key thing to keep in mind. The MBA Alta model and Rulona are internally, policy-wise, they're consistent with each other, but the MBA Alta model is designed basically to sit on top of any state's existing notary laws as like a strap-on, add-on addition to it. And with appropriate cross-references, you don't have to disturb the existing body of notary laws. So it's intended to be an easy lift for states that don't already have Rulona, because Rulona itself is a comprehensive law that requires a complete rewrite. So for states that already have Rulona, there is no policy difference by going the MBA Alta route. Now there are a couple provisions in MBA Alta that Rulona doesn't have, creating a criminal offense, for example, but those are what I would call peripheral questions. That's the main distinction is MBA Alta is more appropriate for states that already have comprehensive notary laws, and they just are looking to add remote notarization to it.
Okay, thank you, Michael. Well, it kind of depends on the next step would be the comparison, send out the comparisons of the Rulona and the Alta model, and we've got a good, shall we say, selection of the various states that have have gone down this road. So I see there's at least a couple of meetings for the work group to kind of go through all that stuff and decide whether one or the other or the blank page is the better way to go here. Anyone see a different way about it? I'm certainly open.
Marisa, from the legislative counsel's perspective, would one be easier? Would one be more in line with Oregon law? I'm just curious.
I don't think we have that much law to begin with, so I think you can, and anyway, we can draft whatever.
Peter, as a regulator, what is your thought?
Well, I believe we did adopt Rulona in 2012, correct? Yeah.
Yeah.
So, we're on board. It looks like everybody's moving in this direction. So I think it makes sense for Oregon to do likewise.
Okay. All right. That sounds like kind of the plan. Heather, you walked in at just the right time.
I'm sorry. Some days I can't get off the phone. I have to learn a new skill.
Heather, we've kind of identified that everybody's in favor of going down this road of remote notarization, and on the phone we've got Tommy Brooks from Kimball Houston and Melissa May from Duffy Keckle as kind of weighing in on estate planning things. Do you have any concerns about just going down this road, and then maybe if there are potential exceptions that you might want to talk about?
So I do have concerns, and I'll tell you kind of where the concerns arise from. And I try never to complain unless I have a solution. So what some of the options we might have could be.
So for those of you who don't do estate planning, there was a major transition in wills in the last legislative session, and here's what that was. There's called a substantial compliance doctrine is the nice name for it, and here's what it means. It means if you intended to do a piece of paper that was a will, and you didn't sign it right, you didn't have it witnessed, maybe you had it notarized instead of witnessed, or you just signed it and you thought that was enough, that the law will now treat that as a will, subject to some higher degree of proof in getting it admitted to probate. So yeah, that means you can sit at a bar and write your will on a cocktail napkin and sign your name, and that's effective. The difficulty is that a lot of people think that the act of notarization results in some higher level of validity. And so many people sign wills in front of notaries that are not properly witnessed. And that, in Oregon, I'm pretty sure you can get that admitted as a will now without the higher function of the witnesses who are willing to say the person knew that they were signing a will, they knew who their family members were, they knew how their will distributed the property, and they knew the value of the estate. So if we're going to go to remote notarization, and you can get a will admitted that has been remotely notarized, there's a lot of room there for people who don't have capacity for wills to be properly identified by the notary and sign the will in front of the notary and have the will notarized. And so there's no protections at that level. At least physically, when you see a person signing a will, some protections there because when they walk in, their level of confusion may or may not be obvious. But so I'm concerned about, yeah, we now do these really easy wills. That's the first thing that concerns me. I'm concerned about financial abuse, where my idea of this remote notarization is you kind of see each other like Skype. The software is you see each other like Skype, and the person confirms your identity, you provide the identifying information, and that notarization is a confirmation of identity. That's all that it is. Is that right?
Well,
Peter, it's not more than a confirmation of identity, is it?
I don't know that that's necessarily the only thing. I think that what you have, in addition, is you have some kind of audio-visual record
of the situation,
of that interaction.
And they actually preserve those.
Yes.
Yeah. Okay.
So that I see as, shall we say, memorializing the event in a fashion that is reviewable by, somebody in worst case scenario in a court.
Yeah.
Taking a look-see, as opposed to having the 19-year-old now guy at the UPS store saying, "Yep, that's what I saw."
True.
So I think it's a benefit, and I've got hands coming up here, so I'm going to go in the room first, then onto the ether. Liz.
So one thing that remote notarization offers is the knowledge-based authentication questions. So if someone is trying to help someone sign online and be that person, physically look at the camera, but actually sign for them because they're not maybe necessarily there, the questions that are asked are questions that would be incredibly difficult for someone to forge on their behalf to get them into the system. We've had people fail out of the system already because they can't remember the color of their 1997 Volvo they had, 15 years ago. It's those kinds of questions that, unless you truly know the person and sometimes are that person, it is going to be very difficult to answer on behalf of them because of the weird and unique questions they have.
So where does that question pool arise from? From public records?
Public records, LexisNexis provides a lot of them. I believe some of them go through Equifax. So it's a lot of the similar questions you see. If you go online and open up a bank account, or you open up a credit card online, it has those exact same similar questions where some of them are so close, but you don't feel like it's right. You say none of the above, things like that make you question your own memory, even for yourself.
The Volvo was blue, by the way.
Yes.
So that's really interesting, you know? What if you can't remember but you still have contractual capacity? Then do you need to go to a physical notary?
Yeah, so you'll have two tries within 24 hours in most systems. And then after that, if you're not able to do it through that, then we find a different way to help you notarize your document, whether it be you come into the office or someone comes out to you. So this is like a first attempt, and it's not like you don't get to have it notarized if it doesn't happen. It's just maybe that platform wasn't right for you because you're not as tech savvy, or maybe your memory wasn't that great with that. But then you have someone will be coming into the office knowing that this person failed on a remote notarization platform, which if it is a fraud scenario or diminished capacity issue, it might tip off the notary to then be more keen into, is there an issue with this person knowing what they're signing? Is it just that they couldn't remember that dang Volvo color? You know, whatever the case is. And the notary doesn't actually know which questions are asked, but they will know also that they're moving off of the remote notarization platform.
So if I'm,
Sorry.
Heather, can the person who failed the first time around then shop to get a different notary?
It would be going through their lender, so I think it might be a little bit weird. But they do get another attempt, and they get usually, I think it's I believe it's 5 questions, and then at least 4 of those questions have to be replaced by new ones or new answers, and kind of switched up a little bit so no one can write down what they answered and know that that's incorrect. And after 2 fails, then you move on with that and work with your lender and title company to figure out what the next step is.
That's the lender and title company rules. Are there rules separate from the lender and title company software system? Or is it all the same software system?
Well, there's a couple different providers. And Renee, do you want to speak to what you guys do? She works for Notary.
So, yes, so the system generally in how every state has been, except for Virginia, but how every state has pretty much enacted the law, whether it is MBA or the ULC model, is first the borrower provides some type of seed data, not the borrower, sorry, the signer, whether it is a borrower or we're in the scenario here of a will or a trust or even a child's permission slip. You start with the signer has to first be identity proofed using these enhanced automated technologies. So they provide some seed data that then goes to, like, say, a provider, like I think Liz mentioned, they use LexisNexis. Some seed data about that person goes to LexisNexis through this platform. LexisNexis then serves up to all signers a series of 5 questions, and you usually have 2 minutes or less to answer those 5 questions. So you're also timed. I think as Liz mentioned, if you fail out of that first time, you get a second time, and then you can no longer have that document remotely notarized by that notary on the platform. You can, I believe in a few states, do allow you to go to another notary and try, but at a certain point, the vendors like LexisNexis won't even let you continue to try, because on their side themselves, they won't even serve it up, because based on their own information, 2 or 3 times in a week is indicative of fraud or potential fraud. So if they cannot answer, it does typically turn into, you have to pay for out, I'm sorry. But then after they pass those, and it sounds like maybe we just need to either do a demo or just send around a video for folks to watch, but after you pass those KVAs, you then go into credential analysis, and that's where you have to provide the front and back of your driver's license or a government-issued ID that usually has a photo and a signature, again, depending on how the state has enacted their laws or rules. And then it goes through an automated system. It could be a LexisNexis, an IdenTrust, an Ideology, whomever, and they provide certain information back to the notary. They also run these automated tests on, at least one automated test on a barcode or how the image of the document looks. And then they provide, again, a pass-fail and perhaps some additional information to the notary, depending, again, on your solution. So then the notary is getting, they pass the KVAs, and then they also they pass the credential analysis. And they're typically served up, at least on our platform, a copy of the front and back of that driver's license so they can see what was presented to them and also see it with the signer when they initially joined.
so there's actually more protections by using the remote notarization from shopping.
Right. Peter, you had a question?
Yeah, I guess a couple of questions. So, I mean, it sounds like there's protections involved in a lending environment. So there's a lender involved. They know, we've got documents out there for a borrower to sign, kind of across their platform or network of e-notary providers. But how would an offline notary say at that UPS store that's not connected into the network. So if somebody gets rejected from doing the remote notarization or an e-notarization, and the document then gets printed out and taken to an offline notary, how is that notary going to know that there have been a number of failed attempts? Is that up to the lender to say, time out, you know, there's a problem here, or?
So in the lending environment, the title company would know, and generally the lender as well, that you're attempting different notaries and trying, because they're going to control when you close the documents, where are we sending the documents, so that the title company will know how many failed attempts and where they're sending it to, and obviously restrict it to a certain extent and evaluate what's going on. If it's just a different document that's looking to be notarized, and they're trying to do it through remote online notarization, the different platforms pull from generally the same area of LexisNexis behind the scenes, so they can't shop for different remote notarization platforms. But if they do go into the UPS store after they failed the remote notarization, they're basically what happens in life today is you wouldn't know. You wouldn't know. Yeah, so you'd have to rely on the old school tactics of figuring out if this is an issue or not.
Okay.
So I could go into the UPS store and convince the clerk that notarized this general power of attorney for my aunt, and then I could do a remote notarization of the loan documents.
I don't believe, speaking from our system that we're affiliated with, which is we're not currently set up to do the power of attorney situations yet. I know it's being looked at. I'm not sure if Notarize does that as well, but I know Renee can speak to that.
Renee, how about if you comment on that if you could?
I'm sorry, you guys just went in and out. Can you repeat the question real quick?
Sure. My scenario was I physically go into UPS.
Hold on, someone's moving. I'm sorry, I can't hear.
Okay, I physically go into the UPS store and convince the 19-year-old that my aunt has capacity and she's having a good day, and I'm granted a general power of attorney, and then within that same week, I tried to do a remote notarization to do loan documents. Is there some protection for that kind of situation?
So I think it would be, again, dependent on what the lender and the underwriter are comfortable with, and if they will allow a power of attorney to be used and for a remote online notarization. I believe right now, and I'll have to double check before I say this 100% certain, but I do not believe right now any underwriter is allowing a power of attorney to be used for purposes of remote online notarization. So a lot of that is again policed at the when we're in the real estate scenario at the underwriter, title company / lender level.
Great, thanks. Peter, did you have a question?
Yeah, I guess the follow-up was really then, so I understand, you know, kind of the push behind the mortgage lending industry, and you know, on the one hand, you've got the video recording, video, audio, and that's going to be a better capture of the scenario versus somebody's memory from a year, 2, 3 years ago, and you know, whatever they happen to record in their paper journal. Is there, have any states just carved out that will do remote notarization for mortgage and title documents in a lending environment and excluded wills and powers of attorney and other estate transfers?
I know Nebraska's law had a carve out to specifically take wills and life estate documents out of the negotiation for that.
Okay.
So I know that not every state has. A lot of the Relona states have just granted it and then provide regulation on top of that if they needed to make it more strict in those scenarios. But Nebraska's the only one that out of my states that I saw did a specific carve out for that. And
I guess with that, is having that video recording then in those will and power of attorney, is that a better protection for, say, a vulnerable person or for an estate if there's a video that can then be entered into evidence later and reviewed as opposed to just somebody's memory?
I mean, right now, the only thing you can do is ask the notary what they thought was going on. So this does offer a lot more people to see what actually happened, and So then you have the issue where some people might say like, oh, I know that they weren't in the right mind because they said this or they wore this, or, you know, those little nitpicky scenarios. But in a court of law, I would think that a video would be a lot easier to review and see what happened versus take one person's word over it. Not to say anything against what notaries do, but.
This is Michael O'Neill at First American. I will just echo that from a corporate title underwriter's perspective, whose job it is to write the policies that we follow of when we will or will not accept a power of attorney. I can tell you that we heavily scrutinize any power of attorney even today for just all the reasons that have been discussed on this call. But if we were to have our druthers, if we were going to be accepting and say, yes, we will accept this power of attorney, I can tell you from an underwriter standpoint, we would be much more comfortable accepting a remotely notarized one, because today, essentially, with a paper power of attorney, you're presented with a document that's been notarized, and the notarization is essentially a black box. You have no idea what processes went into that. In the majority of states, the notary isn't even required to keep a journal. So other than tracking down and trying to see if the notary remembers this signing from 2 years ago, there's essentially no way to audit and create a factual record after the fact. You're just being presented with a take it or leave it underwriting proposition, which is one of the reasons we are very skeptical about relying on powers of attorney for all those reasons. And so a remote notarization giving us an auditable record to go back and look at if we have questions, I think it's just from an underwriting standpoint is superior in every way to a paper notarization.
Anyone else? Gone down various rabbit holes.
Yeah. Well, I think Heather originally, in her initial question, is the remote notarization just about identification, or, you know, their requirement for capacity to determine willingness and capacity, and that's central to the role of a notary. So, you know, with identification, does the person know what they're doing, and do they have the capacity to understand, and are they doing so willingly? So.
Well, the reason I'm curious about that question is we talked last time about Florida had theoretically done some protections for the elderly, so I tried to find them, and the only thing that I found was nothing specific towards remote notarization, but it was a carve out for voluntary nature of the act and competency. And it was the opposite of the Oregon statute, which I thought was really interesting. And when I say the opposite, what I mean is in Florida, you're prohibited from notarizing if there's capacity or voluntary issues. In Oregon, it's 194-245, and it says you're not prohibited, but you may refuse if you are not satisfied that the person is competent or that the signature is knowingly and voluntarily made, which I think is a really interesting difference, because one is an absolute prohibition, which I think works better as a protection. And the other is, well, if they're satisfied, it's okay with us.
Yeah, if you can argue it.
Yeah, which maybe when we go about, I'm supportive of remote notarization. I'm just concerned about, do we need to put in some protections? And maybe that's one of the protections we need to think about, is instead of the ability to refuse, we think about the prohibition against notarizing for persons who appear incompetent. The other thing that's really helpful in the Oregon statute that I didn't see in some of the other notary, I'm going to look at Virginia and Nebraska, but I didn't look at those two, but I was looking around. In Oregon, we have some liability provisions for a notary who causes damage as a result of a notarized act that wasn't done properly. And I think that that's kind of a, it's at least a $200 consequence. But of course, the filing fee for bringing the suit is more than $200. But it's under 194-405, where you're entitled to actual damages or $200, whichever is greater, and attorney fees. So it kind of dovetails the elder abuse statute. So those are just interesting things. I am concerned. I hate the substantial compliance rule as a lawyer for wills. And a lot of the bar hates it with me, but a lot of the bar likes it. So the bar that likes it won the day, and I'll just earn more in fees. But I do think that we need to carve out some stuff for protections, and I would like to see, instead of a permission for refusal to notarize something, we have a prohibition against notarizing something.
Well, I think that kind of tees up the fact that we need to take a look at these models and come back at some point in time to kind of decide which road we want to go down. And then Marissa gets to put it all into Oregon language, and we go from there. So is that the consensus, or does anyone see something different? I get a lot of nodding of heads, and I'm not seeing any nodding of heads from the phone. So you all out there in the ether, tell me if that's what you'd like to see.
I think that's the next logical step.
I think it sounds like a good idea.
I agree.
All right. Well, great. Then Sandy's got the job of sending out some documentation to Harrison, and if anyone has thoughts about things, certainly shoot it to Sandy, and Sandy will disseminate to the group. We are obviously not looking to this legislative session to do anything. Trying to stifle her laughter.
But we are looking to the short session. Is that the goal, or are you looking?
I would prefer
to go 20?
I would prefer
Short session.
I mean, there's some fundamental challenges to getting a bill into that mix during 2020, but if we can find a member who is willing to work with us, then sure.
We'll find something.
More importantly, I think we may find a committee as well.
A committee, that's a great point, thank you.
Yeah.
Yeah.
Well, and if you can get a committee that feels pretty vibrant.
Yeah.
Then your recorder's office are going to start seeing remote notarizations from other areas. Because electronic signatures are accepted, then you're going to start seeing them come in, and if your recorders aren't prepared, and then your notaries are missing out as well, unfortunately. So I think it's a big win if you guys pass this sooner than later, but I know short session is going to be uphill battle sometimes.
Privacy is such a hot issue right now that creates some real challenges potentially. And just kind of looking down the road because
You guys are sandwiched between.
Out loud here, but
Yeah.
what California's doing, what they try to do in Washington with the CCPA, and to the extent where this touches upon privacy issues, it could be a big challenge, especially in short session.
Do you guys know if Oregon's looking into their own privacy law, like the GDPR copycats, or? I know there was the audiovisual one.
Nothing with this session, but certainly,
Cause that's
I think we're gonna have an interim worker.
okay. Cause I was involved in the Washington one to try and we're obviously involved in the California one. That's not my state that I cover, but the privacy issue is definitely a bigger and broader topic than this little one. I do think it's important to separate, but it's gonna take up a lot of time.
I think we need to be smart now about how we're presenting this issue to other attorneys and maybe to other watchdog groups like Disability Rights Oregon or whatever it is. So what do I mean by that? Well, the key factor is they keep a video record.
And we can do,
some little short blurbs about what, as a practical matter, is remote notarization. And if we can get that out there ahead of the idea that we're going to be, or, simultaneously, I think we're going to have less objection to it, because I came in thinking, oh, that's a really stupid idea. But then the more I learn about it, the less I think that it's a problem at all.
Well, it also may set standard, if you will, of what is competent notarization. I mean, it may make UPS say, oh, well, if we're going to notarize, we're going to do it with a video record.
Yeah.
And that, shall we say, ups the bar maybe of what is acceptable out there in the big wide world.
And if it does help, we can also do other groups where, I know Nexus Technologies, which is one of our affiliates, can do a demonstration. I'm sure Notarize with Renee on the phone can do a demonstration as well to help show and walk through how this actually works, what it looks like, and get people more comfortable with it before we go in.
Well, that would be helpful for next time. I'd like to have a YouTube or whatever it might be, just to do a walkthrough and make sure that we're all comfortable with the concept, and then make our decisions and hand it off to Marissa to make it all nice.
We'd be happy to come out and do an in-person demo, or even if you want us to just do a remote demo over the remote platform, we'd be glad. So.
Great.
Yeah, Renee, this is Sandy. I can work with you on setting that up.
And I think there's a particular group of judges that we want to approach. In the estate planning and elder law arena, we have done really great legislative footwork, like we did awesome stuff for a power of attorney statute, and we worked years on it with Oregon Bankers Association, and a group of judges came over in their judicial authority to the legislature and totally tanked that beautiful, helpful, protective legislation because they didn't understand. And so I don't want to see this legislation get tanked in the same way. And they're very effective. They show up in front of committee and say, I'm a judge and this is a bad idea. They carry a lot of weight, even though they're not well informed.
Well, we'll do that.
They're always opinionated.
Judges, I'm sorry.
Yeah.
This won't stop, but you mentioned the judge issue, and I know the other issues we've had that there have been challenges with the judges, to put it frankly.
Yeah.
Not practicing anymore, so I feel like I actually did that. But, do they need to be part of this, or are they a part of this?
With the judicial department. Yeah, I'm not a judge, but,
Yeah. Sam's here from the judicial
yeah, I'm
department.
here to sort of be a fly on the wall and distribute information.
I just know some of the groups we've had some challenges.
Oh, yeah.
It's really, I know exactly who that judge group is. Sam, if you went to that judge group, they'd say, thank you. If we go to that judge group in advance and say, hey, I want to show you what we're talking about, we're going to get a different response.
We certainly could invite folks. It depends on what the work group, how the work group wants to approach whether the judge would be a member, and that's happened on past work groups, or whether they would be a visitor on certain meetings.
Well, I think we need to package it to be able to, shall we say, put it in front of them and walk it through to, shall we say, diffuse lack of knowledge. But judges are, shall we say, notoriously strong on volunteering, yet not showing up. And we want to kind of make sure that is not a way of dealing with this. So
We want to go to them. I don't think putting them on this committee makes any difference.
Understood.
Early.
Okay. So at least from my summary is we're looking at something for the 2020 short session. We're going to kind of look at legislative models, if you will, of which way to go next meeting, and make sure that we understand the concept next meeting. And then we're relying on Marissa to make it so. And I would hope that we have input about the security issue, and if there is an interim work group, that we know where people are going. Have I missed anything so far?
Something I would add, I think it's important looking at 2020. Assuming we're successful in getting some committee to sponsor our legislation, I think we should have a goal of presenting something to them in September, because we want to be way out ahead of the 2020 session start. we're gonna do to this group. I think a similar one in September to that committee would be great.
And
I think we have to have our language completely all wrapped up, but I think conceptually talking to them, in that September hearing, assuming we have legislative.
Yeah, well, that kind of identifies the timeline of making sure that we're getting our work done in the next couple of months, maybe 3 months, and be able to be in a position to put the arm on some committee to give us some time backing.
Deadlines are gonna come anyway, as far as state legislation.
Right. Okay. Anything else from the ether or anywhere?
This is Michael O'Neill. I would, just in parallel effort, I would suggest, we've talked about a couple of provisions of existing Oregon law. For example, the standard of competency, maybe the fees provision. Maybe if folks on this call take a scrub through existing Oregon law and see if there's anything that they could see that might need to be tweaked along with adding remote notarization, like those two provisions we mentioned. That may be helpful too. There may be other stuff that pops out from a review of current Oregon law.
Well, I'm going to task all of the members to identify potential issues in the next 2 or 3 weeks.
Send those to me, and I'll get those out to the group.
So Heather, that if you have things that you want to raise, and anyone else, so let's go that way. So we're looking at Sandy's going to send out a calendar thing.
I'll send out a doodle like I have.
And we'll go from there. Anything else for the good of the order?
So just time frame, we're looking at next, 2 weeks, 3 weeks? Mark, any thoughts?
I'm like the June 20th week. That's when school gets out and a lot of people leave.
So maybe before that?
Yeah.
Okay.
I'd like before June 20th.
Yes, by way of the rhythm, we have a deadline coming up as far as posting for work sessions this Friday. 2 weeks from this Friday is when work sessions have to take place. So from over the next couple of weeks, and then kind of that final push. For some of us, maybe not a lot to do, and then on the other hand, so it's just going to go down.
We'll definitely have the meeting either in this room or across the street, so it will be convenient for folks who are working with the session, and I think we could probably get something scheduled.
Okay. Thank you all for your participation, especially those in the ether out there. And thank you. I think you've got an extra 40 minutes.
Thank you, everyone. I'll be in touch.
Thank you. Have a good one.
Thank you.
Thank you.